the 2nd of December 2025, and this is a sitting of the Standing Committee of Finance in the Western Cape Provincial Parliament. My name is Leon van Wyk. I'm the chair of the Standing Committee. Today, we will be receiving a number of briefings on the status of the gambling bill and the process that has followed with the bill since its introduction in 2018. This, unfortunately, is a fairly complex process, and there are a number of presentations and briefings that we will receive today so that it can then enable us as a standing committee to become acquainted with the status of the bill and where we stand in relation thereto. What I'm going to do at this stage is just give everyone an opportunity to introduce themselves. This is a meeting that's been held virtually, so everyone is online, and so I'm going to be handing over first of all to the members of the committee to introduce themselves, and then we will also just welcome and greet all of the other attendees, including the Department of Trade and Industry and Competition, Advocate Jenkins from the National Assembly is due to join us, and the Western Cape Gambling and Racing Board will be joining us, as well as legal advisors from the Western Cape Provincial Parliament. So I'll hand over now to members to introduce themselves. Thank you.
Good afternoon, Chairperson. My name is Noko Masipa. I'm a member of this committee. Thank you, Chairperson.
Thank you very much, Chairperson. My name is Khalil Brankes. I'm also a member of this Finance Committee. Thank you.
Good afternoon, Chair. Dave Bryant, member of the committee.
Good afternoon, Chair. Good afternoon, colleagues. Noel Constable, member of this committee.
Good afternoon, everyone. I'm Member Boyson. I'm an alternate member of this committee.
Afternoon, everyone. Nama French Mbombo. Thank you.
Thank you very much for that. I'm joined by the procedural officer, Ms. Aida Adams, and I think I will now hand over to the various other participants on this meeting, who will also be providing us with briefings. So over to you. I see, but before we do that, I see Member Bryant's hand is up.
No issue, Chair. Sorry, somebody else had their mic on, but it's off now, so it's fine.
Okay, right. Thank you very much for that. I think if we can then go ahead with that, I'm going to just turn my camera off in the meantime as well. I see the gambling board boardroom members were wanting to announce themselves.
Good day, Honourable Chairperson, Honourable members of the committee. I'm Claude Bassodade, Chairperson of the Western Cape Gambling and Racing Board. Thank you very much for the opportunity to presentation. I'm joined in the boardroom by colleagues who will ask to introduce themselves to you, please.
Good day, Bruno Abrams, CEO, Western Cape Gambling and Racing Board. Good day, everyone. Alvin Matthews, HOD ICT.
Good day, everybody. Liesl Hartman, Legal Manager.
Thank you.
Thank you very much. I think everyone
I'm Marlene. Sorry, Chair, I'm
Marlene.
Chair, I'm Marlene.
Sorry.
Sorry, Chair, I'm Maureen Leroux on the board of the gambling board. Thank you.
Thanks.
Good afternoon,
Chair,
Chairperson. Mazan Venter, board member.
Afternoon, Chair. Ayanda Vandaba, board member.
Good afternoon, Chair. Mervyn Burton, board member, Western Cape Gambling Board.
Okay, I'm just checking for the DTIC and Advocate Jenkins and any other participants. Please just introduce yourself quite clearly so that we can hear you. It's obviously a little bit difficult having as many members on an online platform here, so I think if we can just speak up, thanks.
Good afternoon, Chairperson. My name is Dr. Evelyn Masoja. I am from the Department of Trade, Industry and Competition. I am the DDG responsible for regulation. The National Gambling Act is a legislation that of interest for this meeting. I'm with a team, the acting CEO of the National Gambling Board, Mr. Lungisa Dukwana. I'm also with Marisa van Niekerk from the Department Legal Services. I'm with Saroj Naidu, our Parliamentary Liaison Director. Tsulufelo Shale is also on the team that is with me. I'm not sure if the acting CEO is with other colleagues, but this is the delegation from the DTIC side. Thank you very much.
Thank you. Thank you very much for that.
Chairperson, if I may, good afternoon. My name is Frank Jenkins. I'm Senior Legal Advisor of Parliament. I was also tasked to assist with this bill since its inception. Thank you very much. I don't have anybody else to introduce with me. I'm on my own. Thank you very much.
Thank you. Thank you very much. I'm just looking.
Afternoon, Chair.
You can go ahead.
Yes, from Provincial of the DDG for Fiscal Services. I'm also joined by Ms. Claire Horton and Mr. Malcolm Poison. Thank you, Chair.
Thank you. Thank you very much, Mr. Senna. Your link there was quite indistinct, so I think that perhaps you just look and see that there's greater clarity there on your line. Is there still are there still persons needing to introduce themselves?
Yes.
Afternoon, members. I am Mpho Kwele, the legal advisor to the Western Cape Provincial Parliament. Thank you, Chair.
Thanks, Advocate. I see Astrid Miller's hand is up.
Good afternoon, Chair and members. I am a state law advisor at Legal Services Department of the Premier Western Cape Government. Thank you.
Thank you. Thank you very much. I'm just quickly going to check through if I've noticed anybody. I see Nick Nichols also, hand is up.
Thank you, Chair. Nick Nichols, board member, Western Cape Gambling Board.
Thank you. Thank you very much. I think it looks as if we've covered everyone at this stage for introductory purposes. And I'll just turn my camera back on. Yes, we've dealt with that. I think just to help the process through today, I'm going to request the DTIC to present to us on the flow and the status of the gambling bill. And once they have concluded, we can perhaps just take a short round of questions. If there's any clarification that is needed by members, I think we must just bearing in mind that that each of these presentations will take some time, and we all just need to manage our time fairly precisely this afternoon. So we'll take Advocate Jenkins after that, and then we will deal with give the Western Cape Gambling and Racing Board an opportunity to make their presentation, followed then by Advocate Kule. So I think I'm going to hand over to the DDG then from DTIC, and I'm not sure who will be doing the actual presentation there. Thank you very much.
Thank you, Chairperson. I will be leading the presentation. I'm going to load it quickly. Just a minute. Yeah. All right. Chair, I want to just verify if the presentation is visible.
It is visible, and I'm just also requesting our team of the members perhaps just to note any slide numbers there that you may wish to raise any questions on. But over to you, DDG.
Thank you, Chair. Thank you so much for the opportunity for the DTIC to present to the Standing Committee. We will be covering quite a bit, so I will try to be as quick as I can. But the history that this presentation will cover will be from 2018 until recently. So it will be quite a few slides that are going to be presented. So we have been invited as the DTIC to brief the Western Cape Standing Committee on Finance on the National Gambling Amendment Bill 2018, B27D 2018, and also the bill that was tabled in 2018, which was a B bill. So we were invited to give the processing of the bill from until presently, the concerns raised by the stakeholders during the processing of the B version of the bill and during the mediation committee discussions, and the amendments agreed to leading to the D version of the bill. So this presentation will cover all these processes from then to now. In terms of the legislative process, I will try to speak to it overall. The DTIC published the National Gambling Policy for broader public participation on the 15th of May of 2015. At the time, we were called the Department of Trade and Industry. It was not yet the DTIC. Written submissions were received, and there were direct engagement with immediate stakeholders, and there were public consultative workshops that were conducted until September of 2015. Then the National Gambling Policy was approved by Cabinet in 2016, February the 17th, and the bill was drafted pursuant to the approval of that policy. On the 30th of September of 2016, the bill was published for broader public consultation. It was published for 45 days, and direct engagements with stakeholders and the public then took place until early 2017. Then we submitted the bill for verification, vetting with the Office of the Chief State Law Advisor for certification in 2018. This process was concluded in May of 2018. And later, the bill was tabled to Cabinet, and Cabinet adopted the bill, approved that bill in June of 2018. And then the department then published the notice of intention to introduce the bill to the to Parliament in the Gazette, and this was done in July of 2018. The bill was introduced to Parliament and referred to the committee on the 21st of August of 2018. Then on the 12th of September 2018, the committee was briefed by the Department of Trade, Industry and Competition. And then on the 19th of September of 2018, the committee called for written submissions, with the closing date for submission being the 12th of October in 2018. And also the committee held public hearings. In terms of the rules of parliament, the committee has the right to approve, reject, amend, or redraft any legislation before it. So on the 16th of October 2018, the committee resolved to only consider provisions relating to the restructuring of the National Gambling Board, challenges of the National Gambling Policy Council related to the quorum of attendance of the meetings, and the National Central Electronic Monitoring System in the bill, and that other aspects will be reconsidered in the next parliament. So there was a comprehensive bill that was introduced to parliament. It was reduced and to focus on governance-related issues of the bill. Just for interest and for sharing, the issues that were excluded from the bill include the following. So these were the ones that we still need to reconsider, review, and maybe retable again, because they were not part of the bill that was reviewed. So they include the restriction of lottery-related licenses under the gambling legislation. For example, betting on lotteries and sports pools. These are supposed to be licensed in terms of the Lotteries Act. However, there has been these games of chance that have been introduced through the gambling legislation, but they are in essence lotteries-related activities. So that bill was addressing that anomaly in the legislation. The bill was also empowering the minister to regulate times of gambling advertising and to prevent unsolicited gambling messages through SMS or internet. And also the regulation of gambling premises at shopping complexes, where it was recommending separate entrances and the prohibition of leasing of unlicensed gambling operators or activities. So to curb illegal gambling activities in established buildings or in buildings. So there was a provision addressing that issue. There was a comprehensive section in the bill dealing with the regulation of electronic bingo terminals in terms of the definition of electronic bingo, the number of licenses or provision for licenses and machines. And also there were there was a provision on amendments that were related to transformation in the industry. And there was another area related to horse racing. Horse racing is self-regulated. However, it was going to be recognized in the bill. And the reason why it was going to be recognized, it's because there was a need to introduce measures such as the standard operating procedure that was going to be approved by the National Gambling Policy Council to address some of the challenges that may emerge or that are existing on the horse racing industry, such as labor issues, some of which have been tabled in various committees in Parliament related to labor issues around transformation, how the treatment of workers, norms and standards, and so on. So that bill was covering some of these aspects. But then because of the timing of the bill and where Parliament was at the time, these were excluded in the bill. So they were never considered further. Then on the 24th and 26th of October, there were public hearings held in the committee. And then between the 30th of October and 15 November of 2018, the committee spent 5 days deliberating on the bill and formally considered and adopted it. And on the 21st of November 2018, the National Assembly considered the Portfolio Committee report and the second reading of the National Gambling Amendment Bill on the 5th of December 2018. So it was adopted by the National Assembly on the 5th of December of 2018. and known as the B bill as you know it now. Then it was referred to the Select Committee on Trade and Industry, Economic Development, Small Business Development, Tourism, Employment and Labor. The bill was presented to the Select Committee on the 30th of January of 2019. The provincial briefings took place during February to March of 2019. The bill was published for public comment. The submissions were received and the department responded on the 26th of February of 2019. The public hearings were undertaken in provinces from February to early March 2019. The negotiating mandates were received from provinces. The department, together with the National Gambling Board, responded to the negotiating mandates. The final mandates that were received in 2019 from provinces indicated how various provinces voted for the bill. So in terms of those who voted in favor, the Northwest, the Free State, the Mpumalanga province, Limpopo province and Northern Cape, they voted in favor of the bill. The Eastern Cape abstained. Western Cape and Gauteng and KZN voted against the bill. At the time, the way that the voting were tabled, some of them came before the sitting of the National Council of Provinces, and some of them were tabled at the last minute. So the report was not, the way it was concluded, it was inconclusive in a sense that some of the mandates were going to be tabled, if I recall properly, at the NCOP at the time. So the bill was referred to the National Council of Provinces for adoption. However, it could not be concluded because of some of the technicalities I just mentioned. In the sixth administration, the process of the Select Committee commenced from the beginning. So a decision was taken to start the process from the beginning. The DTIC briefed the Select Committee on the 16th of July of 2019. The bill was referred to the Select Committee of the sixth Parliament and was revived on the 17th of October of 2019. The DTIC then was requested to brief the portfolio committees in the provinces between the 18th and 27th of November of 2019. Provincial committees provided different views on the processing of the bill, with some of the provinces in favor of submitting the final mandates of the fifth Parliament with the signature of the current speaker then, and others preferred to start the process from the beginning. Sorry about this. Let me just do this. Yeah. In terms of the voting that followed in the process, from the briefings and considerations by various legislatures, the 9 provinces submitted the final voting mandates on the bill. 4 provinces voted not in favor of the bill, and they were Gauteng Province, Western Cape, Free State, Northwest. 3 provinces voted in favor of the bill, Mpumalanga, Limpopo, and Northern Cape. 2 provinces abstained from voting on the bill, and they were the Eastern Cape and KZN, and this was in August of 2020. The table below just highlights the status of the voting as I have included them or highlighted them. Now I'm going to go into the substance of the bill in terms of the policy and what that bill was intending to achieve, or it was meant to address. And I'm going to speak to it as if it's in present terms, in terms of how the presentation has always been, so that I don't distort what was intended. So it will be presented the way it's always been presented. So bear with that in terms of the present tense versus referring to it in the past tense. So what has always informed our work as a policy principle underpinning the gambling policy in the country we always started with the WIAN Commission, which recommended the strict gambling or the strict regulation of gambling in 1995. And following the WIAN Commission, there was a National Gambling Act of 1996 that was passed, and it introduced the National Gambling Board. In 2004, the National Gambling Act amended the legislation of 1996, introducing the National Gambling Policy Council to ensure policy alignment at national and provincial government. And the National Gambling Amendment Act of 2008 was passed into law to regulate interactive gambling, which is a form of online gambling. And that act was not promulgated. The reason it was not promulgated was that at the time when the department tabled the regulations, when they were finalized, Parliament at the time was concerned with the extent of allowing online gambling, the sensitivity for vulnerable minors and vulnerable persons. And their view was that the cost of regulating was higher than the cost of prohibition. So although there was a law that was passed, they were concerned with the allowing it would mean access on phones and other devices, and there will be more problem gambling in the country. So that legislation was not finalized. It was it remained, and it does remain in statute even to date. Then there was a consideration by Parliament at the time to for the overall review of the review of gambling, to look at the future of gambling, access to gambling by communities and society. And that's when the Gambling Review Commission was established by the DTI. And there was a Gambling Review Commission report in 2010 recommending policy reforms. So that was a very important document that spoke to the gambling forms of gambling and the nature of gambling and how gambling should be looked at in the country. So the principles that I was talking about on the WIAN Commission, I'm just going to highlight them briefly. We hold the view that they remain relevant in guiding the gambling legislative development in South Africa. They include the protection of society from overstimulation of latent gambling through the limitation of gambling opportunities. So meaning that the protection of society is vital, ensuring that gambling is not a source of challenges where there's overstimulation of vulnerable members of society, and that gambling, there should be a limitation of gambling opportunities. The protection of players and integrity and fairness of the industry through strict control and supervision of the industry. This talks to the monitoring of the industry, enforcement of issues, and ensuring effective regulation of gambling in society, in the country. The issue of uniformity, harmonization is another principle of that report. In terms of uniformity and harmonization of policy and legislation at all levels of government across provinces through minimum norms and standards, cooperation and coordination. This principle remains critical to date in terms of how gambling should be addressed in terms of working in collaboration, in ensuring that there's consistency of the regulation of gambling across the Republic. And generation of revenue and taxes for provincial governments and for good causes. It's another principle. Economic empowerment of the historically disadvantaged. It's another principle of the commission. Then promotion of economic growth, development, and employment. The bill that was dealt with from a governance perspective in the National Assembly, in the Portfolio Committee, focused on the following areas. So these were the rationale of that bill. It aimed to provide for the reconfiguration of the National Gambling Board, which will become the National Gambling Regulator, led by the CEO without a board structure. It also intended to provide for the automatic forfeiture of unlawful winnings to the National Gambling Regulator. The National Gambling Regulator, the National Gambling Board deals with issues of unlawful winnings and the forfeiture of those winnings. So these were going to be then dealt with and automatically so reducing a process through the National Gambling Regulator. It also aimed to provide for the quorum of the National Gambling Policy Council to make a final decision in the second meeting with the majority of the members present in that meeting. To extend the National Central Electronic Monitoring System to other modes of gambling, to enhance the powers of the National Inspectorate to curb illegal gambling activities, and to amend certain definitions, delete certain definitions, and other transitional arrangements. The first clause or section I will talk to is Section 10A, which was inserting Section 10A that empowered the National Gambling Regulator to keep a register of unlawful gambling operators, and also that the said operators will be disqualified for 5 years from applying for a license to operate. This is in addition to the criminal sanctions and fines envisaged under the Act. So this section was meant to address unlawful gambling operators and to have a register of those operators in terms of when, how long they can be disqualified, in addition to other sanctions in the Act. And also to say that when a court has convicted an individual for contravening legislation, then such unlawful gambling operator will be listed in the register of unlawful operators. And this section refers to both licensed and unlicensed gambling operators. And there were other administrative matters that were set out in that to say that regulations will follow to outline processes of how to list and how to delist those unlawful gambling operators. And when an operator has a motivation for them to be removed from the register, they will have to then, there was going to be a process for them to approach the National Gambling Regulator to motivate for the removal from the register. And only once the courts had declared someone an illegal gambling operator is when they're listed as such, meaning that a person will not be listed unless the court has declared that they are listed as such. So meaning that the process was tightened to ensure fair processes through the courts. Then we had clause 4, introducing section 14. I'll also speak to clause 5 of section 16. So clause 4 was amending section 14 by inserting subsection 13, which require operators to remove excluded persons from their marketing list. We have persons who are excluded from gambling. It's related to issues of problem gambling, and persons can be excluded from participating in gambling from certain outlets and so on. But in this particular amendment, it talks about the protection of vulnerable persons by ensuring that they do not receive marketing opportunities or they do not receive mailing lists. So this clause was prohibiting that. And also clause 5, amending section 16, subsection 4, provides for the unlawful winnings that should be forfeited to the National Gambling Regulator, subject to compliance with the Promotion of Administrative Justice Act. So meaning that the winnings will no longer be forfeited to the state after a High Court order, as the Act currently is. So it further strengthens the conditions to verify the unlawful winnings. The rationale was that the onerous burden of applying to the High Court was being removed, making the process easier and saving taxpayers' money. And also that the funds forfeited in general are not large sums. So in some instances, the cost of counsel to manage this court proceedings far outweighs the amount to be forfeited. So as an example, counsel may cost 35,000 per day. However, forfeiting an unlawful winning of 500 rands. And it must be emphasized that these unlawful winnings are related to unlawful participation in online gambling. And this is one of the areas of contention that was raised by provinces and also subject to the issue in the mediation process. The next clause section is section 27, clause 12, related to the National Central Electronic Monitoring System, the NSEMS. So clause 12 amends section 27 of the Act to provide that the National Central Electronic Monitoring System will be extended to apply to other modes of gambling. They include casinos, bingos, betting activities under the auspices of the National Gambling Regulator. Currently, the NSEMS only apply to limited payout machines. And this will be a move away from the current system that is self-operated by operators who in turn share the data with the provincial licensing authorities. So this empowers the National Gambling Regulator to oversee the process of the NSEMS, the licensing of the license of the NSEMS. And it also, the clause provides for the national license. The implementing date for the NSEMS, it gives the date for the NSEMS and it gives the powers to the minister to determine the extent of the operation of the NSEMS. The NSEMS is a regulatory tool for the National Gambling Board and provincial licensing authorities to provide independent oversight of the gambling activities. This includes taxes and levies that are due. So currently, as indicated, outside of the limited payout machines industry, the regulators rely on the monitoring systems that are belonging to operators. And each operator has their own monitoring system, which the regulator has no control over. And just an additional background, these limited payout machines were introduced as slot machines permitted outside of casinos. They are limited because only a maximum bet of 5 rand and winnings of 500 rands are permitted. In addition, only 50,000 machines are permitted to be rolled out nationally and are to be introduced in 2 stages of 25,000 per stage. Currently, the rollout of the limited payout machine is within the first stage, and I'm not sure about the figure now as at to date, but when we were having discussions in the mediation committee, the numbers were 15,500 machines rolled out nationally. And at the initial stage, a licensed limited payout machine site is permitted to have not more than 5 LPMs. And the National Gambling Board may approve a limited payout machine site with more than 5 machines upon application by a provincial licensing authority. So this is just to give extra information about what is happening, the status of the limited payout machines. The NSEMs currently apply only to the LPMs, not the other modes of gambling. So the amendment was going to ensure this is extended to other modes of gambling. So I will move very fast on this next slide. It's just to explain the rationale and why the view was that the NSEMs are very important to be addressed the way that the amendment bill was proposing. And I must also add, this is another area of contention that was raised by provinces as well as in the mediation committee or mediation process. So the intention of the NSEMs is to consolidate information throughout the country for all legal modes of gambling. And we saw this as a great step towards government's effort to implement the 4th industrial revolution, the issues around the digital economy, and also enhancing regulatory oversight over the provincial licensing authorities and gambling industry. The existing monitoring systems at various gambling venues will continue to function as normal. So this was another point that we had to emphasize, that this will not disrupt current processes with operators. The NSAMS is a national register as set out in the National Gambling Act of 2004. And this function will ensure that the National Gambling Regulator continues to work as a central repository of gambling information, in addition to that which is already required in terms of the national registers. And the output of NSAMS was going to supply the provincial licensing authorities, manufacturers, operators with valuable intelligence in terms of the gambling sector performance, both at provincial, national, and national levels. The information can also be used for reporting of national statistics, as well as for determination of taxes and levies. And the National Gambling Board will assist with accountability regarding the accuracy of gambling taxes and levies, also the National Gambling Regulator. We also thought that it was critical that the regulator will be directly accountable for the information collected, as opposed to the status quo where provincial licensing authorities have to rely on operators to provide that information. And we were of the opinion and of the view that this will not interfere with the functions of the provincial licensing authorities, but will rather strengthen their ability to regulate. The National Gambling Policy Council the National Gambling Policy included the policy that was published in 2015-16 that I mentioned at the beginning, included the NSAMS as one of the policy proposals, and it was approved as well. The National Gambling Amendment Bill has followed progressive development, and some provisions were added while others were removed in the process. And then we also wanted to say that this provision was consulted in 2017 and has been subject to various consultations in the National Assembly and the NCOP process in the National Council of Provinces. And the policy or the rationale was also that the establishment and maintenance of an NSAM will be the mandate of the National Gambling Board. And it's currently there in the Act, although with the focus only on the limited payout machines. And we saw it as a regulatory function for national government to exercise oversight, and it serves as a national register. And also is an IT system that will improve efficiencies, financial reporting, industry performance reporting, and provide reliable information for auditing purposes. I'm going to skip the slide because it talks to still the motivation of why this was important, but also to highlight clause 15, which is section 33, on the responsibilities of the National Gambling Regulator. And this amendment empowers the regulator to consider applications and motivation from the provincial licensing authorities for acquiring additional limited payout machines for purposes of compliance with the approved criteria. So this provision was to strengthen the additional licenses related to the limited payout machines. Then the next section, very critical section, also of contention and concern, was around the issue around the National Gambling Policy Council. The National Gambling Policy Council is a statutory platform or forum that is in the National Gambling Act. It's in section 63 of the Act. And so with the amendments, clause 26 inserts section 63A, which provides that in cases where there is the National Gambling Policy Council meetings and there's no quorum, the decision on issues tabled will be made in the next meeting, provided it is supported by the majority of the members present at that meeting. So what it meant is that if in the first meeting there is an issue tabled, say the issue is on online gambling and there's a decision that has to be taken and there's no quorum, say the quorum constitutes of 5 MECs and the minister, so there's no quorum. What happens is that that matter will be tabled again in the next meeting. And should in the next meeting there be no quorum, but only 3, say there are 4 members, including the minister and MECs, then the decision can be taken by the majority of the members in that, meaning that they can take a decision. The majority of the members in that meeting can make they can take a decision supported by the majority. So the majority in that number can make a decision, irrespective of the quorum implication. So, so the National Gambling Policy Council is established in terms of Section 61 of the National Gambling Act of 2004 to ensure the policy alignment at national and provincial government. And the council consists of the following members: is the minister, and it includes the MECs responsible for casinos, racing, gambling, and wagering in that province, and other supplementary non-voting members, such as the chairperson of the board, and from each province, the chairperson of the provincial licensing authority. The minister is the chairperson of the council. So I want to correct something, excuse me, for the establishment of the council. I was saying that it's Section 63, it's actually Section 61. So the quorum implications are in Section 63. The quorum is constituted by the minister and at least 5 members of the executive council. And because gambling is a functional area of concurrent competency between national and provincial legislation, and provinces and national, so both are given the powers to deal with the legislation and policy around of gambling. And so there is a need for harmonization, for cooperation, collaboration between national and provinces when it comes to issues of policy, when it comes to issues of legislation and effective regulation of gambling. The minister may convene a meeting of the council at any time, but he must convene at least 2 meetings in each financial year. So in terms of the Act, the minister may designate any meetings of the council to be a meeting of all members or only of regular members, but must designate at least 1 meeting in each financial year to be a meeting of all members. So this amendment is very critical. It's meant to address the delays that were caused by lack of quorum, which affected the policy decisions to be made and other coordination efforts of the National Gambling Policy Council. And I will skip this slide as well because it still explains about the rationale of why we're clarifying the National Gambling Policy Council and the role of the National Gambling Board and the provinces. So in terms of the options, there were debates around options around dealing with the issue of the quorum. So the failure by the Policy Council to meet has negative implications for gambling regulations in the country. And it also impacts on how gambling is regulated in a manner that is not in harmony across the laws in the country and the policy. So the suggestions that were made was about examples were around how to deal with the quorum issue, the disbanding of the council, that maybe there should be a disbanding of the council. And the argument we made was that by so doing, it will not be in alignment with the Constitution, and there will be the risk of conflict with regards to policy and legislative development, and the other issues may arise, and in terms of consistency, harmonization as well. And there will be challenges with that. And then other options presented was around the round robin, to say that ordinarily round robins are used or utilized to cast a vote on matters which have been deliberated for passing of motions, and it helps in terms of matters that have been attempted. They can be dealt with the round robin. We have tried round robins before in the department when the Policy Council was active at the time, and the round robins did not work, so they were not a viable option. And we did check this issue of the Policy Council with the Office of the Chief State Law Advisor, and they also, when they were doing the certification as well, and they found the voting of the majority of members at the second meeting, they saw it as a policy decision that is rational and that it serves a legitimate government purpose. So this was supported also by the process of certification, that's process of vetting as well. And it was found to be constitutional as an imperative from a cooperative governance point of view, in that this was a collective decision of both national and provinces. So that this was retained. The slide is just to illustrate that there was a serious problem with the quorums, and we were trying to show Parliament that between 2013 and 18, only 2 meetings corrected out of the 9 scheduled meetings. So where you see a green is where there was a quorum. And some of the meetings had to be, one meeting was cancelled on the day because they were at the venue, because there was no enough MECs to have the meeting. Some of the meetings took place without a quorum, but there could not be recommendations made. So you can imagine in that period, that time frame, key policy decisions could not be made because of the issue of the quorum. It's a meeting, and some would say, but it's just a meeting. But because of the significance of this meeting from a constitutional perspective and from ensuring the effective regulation of gambling in the country, it was important that something be addressed. And the leadership at the time saw it fit that it be addressed via a legislation. The next amendment is also a very critical one. It has impacted provinces very much. It's related to the National Gambling Regulator. This is another area of contention that was raised in the previous administrations and also in the mediation process. Clause 28 amends Section 64 to provide for the establishment of the National Gambling Regulator as a public entity, which is a juristic person led by the CEO. It repositions the board and replaces it with the regulator. So the National Gambling Board had a board before. So this was going to remove the structure of a board and replace it with a single regulator as a structure. Clause 29 amends Section 65, subsection 1 to empower the regulator to collect and retain a monitoring fee from all modes of gambling for the NSEM. So this was empowering the regulator also on the National Central Electronic Monitoring System to collect and retain the fees, monitoring fees. And also in clause 30, there was an insertion of section 65A and 65B, which provides that the CEO is eligible for appointment for a period of 5 years, which can be renewed for another 5 years. So it provided for the term of office of the CEO. The provision further provides that the CEO must be a fit and proper person who must not be disqualified and must meet all the other requirements for appointment. In Section 65B, the provision was for the functions of the CEO to perform, and it outlines the responsibilities, including those pertaining to the functions of the National Gambling Regulator, the appointment of staff, the management of the financial resources, delegation of certain functions, and the role of the CEO to be accountable to the minister. The bill also seeks to remove the concept of a board comprising of various external members and replacing this concept with a governance led by a CEO with the assistance of the deputy CEO. The regulator, National Gambling Regulator, will be listed as a Schedule 3A, a public entity in terms of the Public Finance Management Act, and will comply with all the PFMA legal prescripts, and is accountable to the Auditor General and Parliament. The CEO of the NGR will become the accounting authority and is required to account at the highest level pertaining to its fiduciary duties. All governance checks and balances are in place in terms of legislation to prevent abuse of power. This was said to address the point about there was a board and then now there's only one single regulator. And the CEO is restricted to exercise power within the confinements of the PFMA, read with the National Gambling Act as amended. Whilst a collective of individuals may present collective expertise, however, it should be noted that for an organization such as the National Gambling Board and the National Gambling Regulator, the institutional memory is built from within the organization and recorded over time. So in terms of the PFMA, the accounting authority can at any time appoint consultants if specific expertise is required for a particular instance. So this was just to clarify why the regulator was still a suitable structure of governance to run or oversee the work of the National Gambling Regulator. And in terms of the DTIC...
Sorry to interrupt you, but also just to give you a moment to catch a bit of breath there. I see Member Bryant's hand is up.
Thanks very much, Chairperson. Chairperson, and I'm sorry to interrupt the DDG. I'm just wanting to find out, because I see the presentation, it's almost been an hour now, and it looks like it's about halfway through. My only concern, Chair, is if we take another hour, whether or not we will have room for the other presentations and the discussion. So I just maybe would like to just find out through you how much time is estimated to remain in terms of this particular presentation. I understand it's important information, but it is quite a considerable amount just from my side. Thanks, Chair.
Yeah, look, I think it's important that DTIC sort of try and move through as speedily as possible. I'm aware that Advocate Jenkins has indicated that from a parliamentary point of view, it appears that his presentation may well be covering the same sort of area. So we possibly could save an element of time there, and he could, just fill in on certain aspects there. But I think it's also important that for the committee to gain an understanding of what has taken place and what's been pointed out here appears to be part of the stumbling blocks that there are in processing this bill. But back to you, DDG.
Thank you, Chairperson. Noted. I will try to be a bit faster. I wanted to make sure there's an understanding, because we realize that some of the issues that I'm presenting normally will come in the form of clarifications in terms of why did we do certain things. So when we were presenting this in different platforms, we realized the why was also important, but I do note the concern of time. So I will try to summarize the slides as much as possible without losing the essence of what is intended to be presented. So on this slide, the point was to say that in the DTIC, we do have other regulators that are running entities without the board. So let me give examples of the Companies and Intellectual Property Commission, CIPC, the Competition Commission as a commissioner without boards. Currently, the National Gambling Regulator does not have a board. There was a time the DTIC took a policy position to focus on to look at the review of entities, because we do have 19 entities, to look at these issues to say, how do we manage the issue of entities? That's one of the recommendations was that we can have a single entity run by a CEO or a commissioner. And there was challenges with some of the boards. At the time when the board was removed by the minister, there were lots of governance issues at the National Gambling Board, just to add that. I'm going to move from the rationale then around the gambling board and the importance of the national gambling regulator to strengthen the mandate of the regulator and the effective compliance monitoring of legislation in the country, and the working with the provincial licensing authorities to ensure effective regulation, effective engagements with the provinces. And then talk to clause 32, which is the section 66A that empowers the regulator to work collaboratively with other government departments. So this is more of a corporate intergovernmental relations provision. And another provision that was of contention is around the powers of the National Inspectorate. And in terms of this provision, there was an insertion in the bill to provide for additional powers of the national gambling inspectors, that they may act with or without provincial inspectors to investigate illegal gambling activities. This is for those cases when the provincial inspectors are not available to accompany the national inspectors. So there are challenges of enforcement in gambling, and the National Gambling Board has some restrictions in terms of engaging with provinces. They need permission to enter into provinces. So the national inspector, even if there's a crisis in a casino or in a particular gambling institution or so, they can't intervene without working collaboratively with the provincial inspector. This was just to increase the inspectorate function, to strengthen the inspectorate, and to ensure that there's more capacity for enforcement by this kind of collaborative work with the province. But that the National Gambling Body inspector, if they needed to go into a province without the provincial inspector, they can be able to do so. It was it's a contentious issue. Provinces raised concerns with it. It was not well received. And also on the inspectorate, there were other provisions that empowers how inspectors can deal with illegal operators and how to deal with investigations, litigations, and prosecutions. So it's just to strengthen those. And also the inspectorates were empowered to be able to notify financial institutions, including banks, related to their to illegal transactions, and working with other regulators such as the Financial Intelligence Center. So this and other financial institutions, just to strengthen enforcement. Other amendments were consequential in terms of where we refer to the board or CEO, now referring to the National Gambling Regulator. And then the powers of the minister to issue regulations in clause 42, section 87, empowering the minister to make regulations for the criteria to be used for the limited payout machines. When they are considering the applications for the provincial licensing authorities. And then the transitional arrangements to say that the employees of the gambling board will be deemed as employees of the regulator, other assets, movable, immovable, the financial, administrative, and records, including contractual obligations and liabilities. Chairperson, on these ones, it's similar to what I was saying throughout, but then to highlight that in the 5th and 6th administrations, these were the concerns that were consistently raised about the establishment of the National Gambling Regulator. Provinces raised concerns regarding establishment of a regulator without a board structure, regarding issues of corporate governance. And also on the NSEMS, there was a concern that NSEMS, which is currently limited payout machines, will be extended to all modes of gambling. The concerns were that casinos and bingos are already having their own monitoring systems, and provincial licensing authorities have access to this information when it's needed. So the thinking was, why then do we need to extend this? Because it's already provided for in provinces. They have access to this. They raised concerns with the National Gambling Policy Council. They opposed the amendment clause that empowers the majority of the members to present in the second meeting to make a decision. So this was a serious issue for provinces. As indicated now, the issue around the inspectorate was also raised about the issues of autonomy and independence of the provincial inspectorate, where national inspectors are allowed to investigate without prior approval. They saw this as interference into provinces. So this was a serious issue. So in terms of the outcome of the bill in the NCOP, the Select Committee tabled its report on the 16th of February of 2021. The committee referred the bill to the NCOP, and then the bill was rejected, and it was referred for mediation committee in the National Assembly on the 14th of December of 2021. And it was announced in the ATC of Parliament as to be referred, not formally referred, because the mediation committee had not yet been established. And subsequently, the bill remained inactive without progress, and it lapsed at the end of the 6th Parliament. And so the mediation of the bill, the bill was then placed on a parliamentary program in 2022. The meeting that was cancelled. It was going to be discussed in 2022 in June. So on the mediation process, the bill was revived in the National Assembly on the 25th of July in 2024. And in the NCOP on the 29th of July. At the stage, it had lapsed on the last day of the 6th Parliament. And under the new joint rules adopted in 2024, the mediation committees established once both houses have determined the numbers to serve on the committee. Thereafter, the bill will be referred to it. The committee deliberated on the bill and formally considered and adopted it on Friday, the 13th of June of 2025. During the deliberations on the bill, there were procedural matters that were raised, including whether the mediation committee's consideration of the bill was procedural and constitutionally sound, given the delays, the delayed referral. And so this is just the background of the issues, but to highlight that the issues that were deliberated by the committee were as follows. It was related to the proposed quorum requirements for the National Gambling Policy Council, and it was related to the National Gambling Regulator to replace the National Gambling Board, the extension of the National Central Electronic Monitoring System from limited payout machines to other modes of gambling, the introduction of powers of the inspectorate to act independently, and also the forfeiture of unlawful winnings. So in terms of the new Bill 27D 2018, the mediation process was a closed process. Parliament is still, the National Assembly, the bill is due to be tabled at the National Assembly. So what I will highlight, without going into the discussions, the merits of the discussions, the outcomes of the discussion, will just be to highlight the changes that were made on the bill. They include retaining the board structure at and the removal of the National Gambling Regulator from the bill. So the change in the D is about that. There is now a board versus a regulator. All the amendments were then effected in that way. And also on the National Gambling Policy Council meetings, there is an amendment for a hybrid virtual meeting is included in the bill. But the quorum requirement remains because it was discussed further. But yeah, the quorum requirement remains. The document includes the amendments of the definition of a meeting, the meeting definition. There's a definition added on meeting. And the report of the committee was finalized and it was tabled, and the committee recommended that the National Assembly and the NCOP adopt the report and approve the second reading of the new version of the bill. Chairperson, this is the last slide. From the DTIC is for the committee to note the bill and its processes. Thank you.
Thanks very much, DDG, for that. It certainly was quite a marathon presentation, and hopefully that provides the committee with a fair amount of understanding of the process to date. I know that Advocate Jenkins was, I got a message during the course of this presentation that I think Advocate Jenkins, you were saying that your presentation was going to cover probably most of this. I don't know, you can perhaps just summarize on that. And then, for us as a committee, clearly what we now need to understand sort of after these briefings that we are getting is, is what is the status of the bill, what is now expected of us, and what is that timing that that we now have. So we would just like to understand how the process is going to work now. And I think as already been indicated, there are a number of amendments that have been put forth and how one deals with that process going forward. So perhaps Advocate Jenkins, if you can perhaps just give some commentary there, and then if there are any questions of clarity from members, we can perhaps take them afterwards.
Honourable Chairperson and honourable members, yes, thank you very much for the opportunity. I can flight my presentation, but Chairperson, it is really, there's a lot of repetition in it because my presentation, it is with the members. It takes the committee through the beginning, the department, but let me start again. First of all, the department made a very good presentation in my view, and covered both the process as well as the substance. So again, thank you for the department for making my life a little bit easier. So Chair, my presentation is there. Maybe there's just one or two things I can highlight. These are questions that came out during the presentations and deliberations in the mediation committee. And maybe just to indicate to members some issues, the legal issues around the mediation committee. First of all, Chairperson, as we've now seen with this presentation, this bill has been revived twice. That does not happen often for various reasons. So we've taken a really long time to get this bill to where we are now. That's the first issue that I have to indicate. Was there a legal problem with reviving it twice? In my view, no, there wasn't. The Constitution permits a legislature to determine its own operations and to make rules to give effect to that determination. So we have rules in the NA and NCOP for revival. And the second revival, Chairperson, which was now after the 2024 elections, that was done very explicitly in the National Assembly and in the National Council of Provinces, more of a broad stroke. Any other business that was not finalized by the House on a certain date when the term expired is now revived again. So that, in my view, was a revival. There were questions asked about that clause in the minutes and in the motion for the revival. But Chair, my view is that when the House establishes a committee and it has a broad revival of all business and they then establish a specific mediation committee for a bill, I think there's no doubt what the intention of the House was. So that's not really in any event for me to question. So legally, I don't see a problem with the revival of the bill. So where the bill is at the moment, It went then through the mediation, and the National Assembly I think they will await further progress in the NCOP part, but houses in the mediation process can adopt the bill simultaneously because there's various versions that must be adopted. And the committee has decided on a version which is serving before both houses at the moment. So the question that has also come up is, can we make further amendments from where the bill is now? The answer is no, we can't. The Constitution sets out that when the mediation committee is considering a bill, it consider either the version of the National Assembly, the National Council of Provinces, or a new version. Now, what we had in the mediation committee was only one version, because the NCOP did not make any amendments to the bill before it after the National Assembly. So that was one version that served before the mediation committee, and the mediation committee made certain amendments, which the department has highlighted. And that is now from the mediation committee side sent to the NCOP. Another, and maybe I should just stop there, otherwise I'm going to start repeating things. One of the questions that has come out during the mediation, as well as subsequently to that, what about public hearings? Now, the Constitution sets a time frame for 30 days for the mediation committee to complete its work. In my view, that's not negotiable. The Constitution sets it. There's no way where we can ask for an extension. At the same time, the Constitutional Court has set various requirements for public participation to comply with the Constitution. And those requirements include translations, notification of meetings, assisting people to come to meetings, etc. So in my view, Chair, when we look at the process of Parliament, the mediation is right at the end, when the houses couldn't agree. The time given is not sufficient to do further public consultation. So we are sitting with a product where public consultation happened there's a historic record of public participation. Of course, a lot of the members in the NCOP are new members who hasn't seen this bill before. But at the mediation process, there was no further public consultation, in my view, because it cannot be accommodated the way the Constitution is written. So that, in my view, the Constitution does not contemplate that there's further public hearings during a mediation process. What is the situation in the provincial legislatures? I think provincial legislatures each legislature has a decision to either approve or to support or not to support the version. As I say, no amendments can be made. So if public participation is necessary for that decision in a provincial legislature or in the Western Cape Parliament, I don't think anybody can tell that legislature, no, you can't. It will depend on the legislature, how they want to do that public participation, what they want to gain from it. Certainly there will be a gain by just connecting with the public out there. But the public should need to be advised that it's not for amendment purposes, merely to say a yes or a no to the matter, because we can't make further amendments after the mediation committee has decided. So, Chair, in short, I see the mediation process as sort of the end bit after public hearings has taken place, and there's no space for further public hearings, which leaves us with a position where we are now, that the public hearings is really the historical fact, and we have to go look at the records. But legally, I don't see a problem with that, Chair. I'll just stop there and take questions, Chairperson, if that's in order. Thank you very much.
Thanks very much, Advocate Jenkins. I think that was, very useful for you to provide, that additional context to, the lengthy and the comprehensive briefing and presentation done by DTIC. So I think at this stage we can then take questions from members on what we've heard so far. So I'm looking to see if we can get some hands. I see Member Brian Sand. You can go ahead.
Thanks very much, Chairperson, and thank you for those presentations. I do think that there was a comprehensive overview provided. I suppose the challenge for us really is considering the fact that previously the Western Cape did not support this, whether or not there has been a fundamental change between then and now that would necessitate a change of heart, so to speak. And perhaps Mr. Jenkins could expand a little bit on that. I know we do have some documents that have been provided for us in terms of the previous negotiating matter, but I suppose if one looks at the presentation, what we aren't currently, I suppose, able to do is look at whether or not there are fundamental differences between what was previously put forward as reasons for not supporting compared to now. Just in terms of a question for maybe the DDG, is the rationale behind doing away with the board and replacing that with the CEO? Can you expand on the reasons for that, and also then how oversight would be conducted to ensure compliance? Obviously, a board plays a very, very important role when it comes to that, in terms of having a regular turnaround and turnover of members who then have to act in that capacity to conduct the oversight. That's it for me for now. Thank you very much, Chair.
Thank you for that, Member Bryant. I think, at this stage, what we do have presentations to be provided by the Western Cape Gambling Board, and then there's also the issue then on public participation that Advocate Kule from the Western Cape also has certain commentary to provide there, and that hopefully will also provide greater context to some of the issues that have now been raised. That on the one side, that mediation committee has come with certain views, and as has been indicated by the DTIC, there are a number of issues that related to that whole aspect of the regulator. So I'm just trying to perhaps just see if we can have perhaps a quick input there from the DDG. And if there are no other questions at this stage, then maybe we can move on to the gambling board's presentation, and then also just get that level of context, and then perhaps deal with that further. But I see Advocate Jenkins' hand.
Now, Chairperson, I don't want to jump the queue, but the question on the board versus the regulator was the fundamental issue within the mediation committee. And the mediation committee decided to retain the board, to go back to the unamended act. In other words, whereas the Amendment Act of 2018 wanted to establish the regulator, that governance structure was, and I'm subject to what the department says, but I mean, I'm looking at my notes here and the bill that we drafted, the amendments, the position at the moment, if this version of the mediation committee is approved, is that there's no change in the governance structure when it comes to gambling boards. The regulator is not going to see the light of day. Thank you, Honourable Chairperson.
Thanks. That was pretty helpful there in providing that level of clarity. Okay, I think what we'll do then at this stage is let us move on to the Western Cape Gambling and Racing Board. I think in terms of the presentation that you've sent through to the committee, and perhaps then if you could run through with that. But maybe just before you start, Member Nkondlo, afternoon to you. You can go ahead.
Chair. I was struggling with my mic, but it's fine. You can proceed. I'll put my questions after.
Okay, excellent. Okay, thank you. Thank you for that.
Presentation.
Okay, right. We can go ahead on gambling board side.
Thank you, Chairperson. We have a fairly short presentation. Presentation is focusing on the comments on the specific amendment provisions, and Ms. Hartman, the legal manager of the board, will do the presentation. Thank you.
Just speak up because you feel a little bit distant. I'm aware of the fact that you're sitting there in a boardroom context. So if you could just speak up, thank you.
Thank you, Chairperson. Ms. Hartman, the legal manager of the board, will do the presentation. Thank you.
Thank you very much, Chairperson, for the opportunity to present our comments to the Standing Committee. Much of what is covered in our submission has been dealt with by Ms. Masoja of the DTI. As you are aware, in terms of the B version of the bill that we had to present onto the mediation committee, there were only 4 specific issues that we were requested to comment on, which was pertaining to the National Central Electronic Monitoring System, the forfeiture of unlawful winnings without a High Court order, the amendment to quorum requirements of the National Gambling Policy Council, and then the establishment of the National Gambling Regulator, as well as issues regarding the National Inspectorate. So just to briefly mention, the board has at various intervals provided comments on the various versions of the bill since its commencement in 2016. And so I'm not going to touch on that, but for to say that we were not requested to provide any comments on the D version of the bill, which is the bill that has to now be decided on. I was, however, informed by Provincial Treasury that they had submitted comments on the D version of the bill. So I'm just going to run through the 4 issues that we were requested to comment on. The first being the National Central Electronic Monitoring System. So the board was not in support of the fact that the system should apply to all modes of gambling. And the reason for that was because we feel that the NGB will then be usurping and encroaching on the powers of the provincial regulators, because in terms of the Western Cape Act, there is a provision that clothes the board with the competence to direct license holders to link to their gambling devices to central electronic monitoring systems. And all the license holders of the various sectors that we license have these systems in place. And the systems works optimally. It has been approved by the board, and it is also compliant with the South African Bureau of Standards and the National Regulator of Compulsory Standards. So the board audits these systems. They collect the taxes, and then where there is information that is required by the NGB, that information is then extracted from these relevant systems and provided to the NGB for them to maintain whatever registers and information they have to keep in terms of the National Gambling Act. Also, an important factor of us not being in support of the incense is that it will have cost implications for the industry, and that there will also be a duplication of certain issues and pertaining to the NKs. So I just also want to mention that in terms of the National Gambling Policy of 2016, there was a discussion that there would be a revenue, that there should be a revenue sharing between the National Gambling Board and or regulator and the PLAs with regards to where the incense system is applicable to all modes of gambling. Nothing in the version of the bills that was up for comment in any of the versions actually was there any discussions with regards to a fee sharing arrangement in terms of what the gambling policy proposed at that stage? So we would replace for revenue sharing with provinces, as provinces are responsible for the management of the data and the reconciliation of financial information on the same systems. Then with regards to the forfeiture of unlawful winnings, we are in favour of the fact that the process shouldn't go by the High Court because of the fact that it is a very costly exercise. We do, however, feel that the unlawful winning should, that the process must go to the province instead of the National Gambling Board. Because in terms of Section 77 of the Western Cape Act, these prescripts says that process of illegal gambling and other unlicensed activities must be forfeited to the province. So obviously the province would like for that funds to remain with the province and not be paid over to the National Gambling Board in regard to unlawful winnings. Then the next aspect of the quorum of the National Gambling Policy Council, we were not in favour of the amendment that was set forward, and the reason for that, or if I can just read Section 63(4) of the National Gambling Act, it makes clear that the council must make decisions by consensus. And if one should proceed with amendments in the manner as proposed in the various versions of the bill, and which is also currently in the D version of the bill, it takes away the whole idea of having consensus amongst the members, because in terms of governance, it wouldn't be correct for just a few members to make a decision, and it's very important decisions that the Policy Council needs to make. So the proposal that we made was for decisions to be made via a round-robin decision-making process, instead of just having only a few members make the decisions in terms of what the Policy Council discussed. With regards to the National Gambling Regulator, as Advocate Jenkins just mentioned, in the D version of the bill, that structure has been removed, and the current structure of the National Gambling Board with an actual board is being retained. So we're very happy for that. We were opposed to the National Gambling Regulator being instituted for a purpose of governance, because we feel that it's good to have a board that can assist with governance, because you will have persons with different skills, disciplines, and experience to guide the board and to conduct effective regulation and oversight of the gambling industry, instead of having just one person that has the decision-making power in terms of how in terms of oversight on the gambling industry. So that is just the gist of that. There was another amendment where the proposal was, and that is Section 33, where the proposal was for the Gambling Board to consider applications and motivations from provincial licensing authorities for the acquisition of additional limited payout machines. And then there was also the proposed amendment of Section 87FA, which says that a criteria must be observed by the National Gambling Regulator to approve payout of machines in excess of 5. So our comment with regards to those proposed amendments, which basically speak to each other, was that the provincial regulators, we issue the license and we enforce compliance by the license operators, whereas the National Gambling Regulator exercises oversight and maintains certain national regulatory registers. The PLAs has exclusive powers and jurisdiction in terms of the National Gambling Act to conduct the licensing and to deal with the applications of licenses So we just feel that imposing an amendment that says that the NGB must consider these applications and motivations as usurping on the functions of the PLAs, and that yes, the NGB can set the criteria that needs to be considered, but that the approval and consideration of licenses, that function must remain with the provincial licensing authorities. Due to the fact that there is a specific powers that is granted to both parties in terms of the provision of licenses or approval thereof, and then with the NGB having an oversight function. Yeah, the other thing, yeah, that's sorry, Chairperson, I just want to get my bearings because I don't want to repeat anything. Yeah, so yes, yeah, I've covered that. Thank you. All right, and then there was a comment, which is a comment that wasn't part of what was before the mediation committee, but that I inserted in the presentation, and that is pertaining to the fact that to section 65, the proposed section 65EB, which provides the NGB with power to collect and retain monitoring fees for all modes of gambling. The WCGOB is opposed to the NSEMS being applied to all modes of gambling. And as previously said, it usurps the powers of the gambling board, and it also be something that will increase the cost to the gambling operators, which we feel is unnecessary because the current systems that these license holders and the industries have, it works optimally, and the board has access to the information. With regards to the powers of the National Inspectorate, the board recommends, the board is not in favour of the amendments because again, it's the proposed amendment is usurping and encroaching on the powers of the provincial regulators, and it also leads to conflict between the national and the provincial legislation on the subject matter. We feel that the PLAs have the exclusive competence to conduct inspections to ensure compliance with the National Gambling Act, and Section 76(2) directs that the national inspectors must enter licensed and unlicensed premises in the company of an inspector appointed in terms of the provincial law. So that is how the law currently is stated, that the inspectors of the provinces must be accompanying the inspectors of the national when conducting these inspections. So we would obviously want for the status quo then to remain, and mainly because we feel it's encroaching on the powers of the PLAs. And yeah, the recommendations is set out in on page 19 of the presentation, but has also basically been covered with what I have addressed in the presentation. Thank you, Chairperson.
Thank you very much. To use the team at the Western Cape Gambling Board for providing us with that presentation and giving us a further understanding of these various matters. I'm perhaps now going to just move across to the legal advice that we requested from a committee perspective in terms of the public participation, the public hearing, and how we deal with that matter, because maybe we've got some input and some comment based on that. So I think we've progressed quite well. We just over an hour and a half into this meeting. And yeah, so I think if Advocate Cooley, perhaps if you could give us your presentation, then that will also be help us in guiding us on the way forward. I think the one question that we perhaps need to touch on after your presentation is what is the timing on terms of the process going forward, in terms of what the mediation committee has now proposed, and bearing in mind that we have almost done the 2nd of December, and I think all of us are going to be thinking of a break now for the next few weeks. You know, a lot of these matters will need to be picked up in the new year. So over to you, Advocate Cooley, if you can lead us through that next presentation. Thanks.
Thanks so much, Chair. I am going to share, I'm going to flag my presentation. I thought it more prudent to prepare rather a presentation other than flighting my opinion. I thought it would be more user-friendly that way.
Excellent.
Let me just get situated here, Chair, just a moment. Thank you, Chair. Thank you, Chair and members, for the opportunity to brief the committee on whether the WCPP is required to conduct public participation on the D version of the National Gambling Amendment Bill. There are 3 questions that I'm going to cover. First one being, has the bill undergone material amendments? And that will inform whether public participation is required. And then once that answer is given, if it's given in the affirmative, does the province have its own constitutional duty to conduct public participation? Chair, members, this is in view of the fact that the NCOP did indicate that hearings were conducted on their side. That is what I gleaned from the correspondence between ourselves and the NCOP. So I just want to make it clear whether we have our own separate duty to conduct public participation. And then another question that I wish to touch on is, at which stage is public participation required? Is it at negotiating mandate phase? Is it at final mandate phase? Or is it at voting mandate phase? So I'm just going to jump into that. So I'm going to start my inquiry into a case law that is very informative regarding whether public participation should take place, and is a guide. So it's the South African Veterinary Association versus Speaker of the National Assembly, SAVA, or SA Vet for short. So in that case,
Advocate Cooley, are you going to try and move your slides along here? Sorry
yes,
to intervene here,
meaning,
because we're still on the first page at this stage.
I'm moving it on my side. So do you see it move?
No, I think our slide, or my slides on my side, feels like a Tuesday afternoon now. So it's probably got lazy for the day now, but I'm not sure if somebody could assist us there.
All right, thanks for bringing that to my attention. There we go.
There we are. Thank you.
So in SA Vet, the central question was there a material amendment? And that is the starting point of the inquiry, because so what happened in the SAVA case is that the Medicines Amendment Bill was under discussion, and after hearings closed, Parliament inserted a new definition of the word veterinarian. Now, it was just a single word, and it expanded, you know, who is affected by the bill, because in effect, what happened is that it brought in a separate class of professionals into this bill that weren't there before. And then after making this amendment, Parliament didn't open the public participation process. And then members of their profession were aggrieved, and they challenged that insertion at the Constitutional Court. So in Sava, the court held that material amendments trigger a fresh duty to consult the public. So what that means is that a change is material if it alters who is affected, introduces new policy questions, changes how powers are exercised, and shifts the scope or the impact of the bill. So even one clause, as seen in Sava, can be material. So, the court famously said that a complete failure to involve the public in a material amendment to a bill cannot be reasonable by any measure. And then we move over to Lamosa. So Lamosa, we asked the question around, does the provincial legislature have a separate and distinct duty to conduct its own public hearings? So who must conduct it? Is it the province? Is it the NCOP? Is it both? And then the court held in Lamosa that the Constitution imposes separate and distinct obligation on the National Assembly, the NCOP, and the provincial legislatures. That means that the NCOP's hearings cannot fulfill the WCP's duties. So every sphere must independently comply. So also, Lamosa said that the duty for public participation, it cannot be delegated. So even if the NCOP has consulted the public, the province must still conduct its own process under Section 118. So another issue, and I think that is very relevant in this instance, is that there is this view that if a bill is lapsed and is revived, the underlying processes are revived as well. So in Lamosa, it said that when a bill has lapsed, compliance with public involvement does not automatically revive. So meaning that fresh public engagements need to take place. And it's even more pertinent here because in this bill, there has been, several lapses, several revivals. So it is important to note that public involvement needs to begin afresh. So when we apply to here, to this bill, there have been, I provide examples here of insertions of 66A and 76A. So 66A and 76A, initially when the bill was amended, it was that there was going to be a replacement, so to speak, of the board with the regulator. And the governance structure was going to fall wholly under the structure of the regulator. And then what we see now with the D version is that 76A and 66A are retained, but the board is now reinstated and the governing structure is different. And what that means is that, the powers, accountability, and practical effect have changed because of that material amendment. So what happens is that on the face of it, it's the same provisions, it's the same numbering. But, we need to be mindful of the fact that in the B version, it was under a regulator, and then in the C version, it's under a board. So, the constitutionally does not, the clause number do not matter. So the clause giving powers to the regulator has a different effect when applied to the board. So that satisfies, the test for materiality under the Sava case. So, once it's established that the amendment is material, now we have to move on to the fact that who has to conduct public participation. I'm going to move very quickly through this because I think it's trite that we know that as a legislature, we have our own duty to facilitate public involvement. The NCOP hearings, they satisfy their own duty, similar to the national hearings, they satisfy their duty. And then in our case, we have a separate duty deliberately put in the Constitution that we need to satisfy that constitutional duty as well. So based on Sava and Lamosa, we did conduct hearings in 2018, but the bill has materially changed. The old participation does not carry forward. The bill has lapsed, but the obligation to conduct public participation, they do not revive automatically. The institutional structure has reversed because the board is now reinstated. So in light of the material amendment and our constitutional obligation, once the obligation has been triggered by the fresh amendment, means that we need to conduct public participation. Now, this is the last slide, Chair. I moved very quickly through this. Now, there's an interesting consideration because, you know, the question arises, where does public participation, at which stage does it happen? So in Lamosa, the court held that public participation is required whether the legislature takes a step that may affect the content of the bill, such as in this stage, it does affect the content of the bill materially. And this happens at any stage of the process, meaning that even at the late stage, whether it is negotiating mandate phase, you know, final mandate, voting mandate, if there is material change within that process, that triggers a new duty and it has to go out to public participation again. So that is just my submission. I've tried to keep it brief, Chair. I don't know if anybody may have questions around this that I'm very happy to answer. Thank you.
Thanks. Thank you very much to you, Advocate Cooley, for that presentation and bringing us up to speed on that whole process of public hearings, public participation. So I think at this stage we can then take questions, and let us just see how that's going to guide us now into the future. I know, Member Nkondlo, you said that you would hold back till now to ask questions. So I'm not sure if there are any other questions that are coming, but Member Nkondlo, if you want to go ahead, you certainly can do that.
No, Chair, thank you so much. Maybe, Chairperson, we may, depending what becomes our conclusion as a committee, because you see, I was just trying from the DDG's presentation to the province, excuse me, to understand that if we're dealing with a bill,
we're losing you a little bit there.
That would have started around 2015 with some aspects of the bill. Hello?
Hello, we're not hearing much. You're probably hearing one in every 7 words at this stage, Member Nkondlo. But I think what you're saying is that maybe you don't have a question right now, and obviously you were trying to draw getting the context from what the DDG provided in the DTRC presentation through to, I imagine, what the Gambling Board and what our legal advisor has given us. That's what I'm sort of trying to interpret what you may have been heading for. The one aspect that I'm just trying to gain an impression and understanding is in terms of the timing of how we deal with this from a committee point of view, and in terms of a mandate that the legislature, that the Parliament may give to the NCOP. What is that sort of timing? Because I can imagine we are now heading towards recess by the end of next week, and everybody wants to get through New Year's Day and try and get a bit of energy together for 2026, which may only be towards I imagine, the 3rd week of January, where we've got enough sleep out of our eyes to tackle the next aspect, and we then move into that whole SOPA and the SONA period and budgets over that next 6 to 8 weeks. Because I was thinking in that period, I imagine, is when we would then need to try and deal with a mandate. So I'm just trying to get an impression then possibly from Advocate Jenkins on how we understand the timing to be.
My apologies, Chairperson. Here I am. Chairperson, I unfortunately do not have, sorry, I had to my computer is losing power, so I just quickly had to move seats. Chair, I don't have the timing schedule. I'm not informed of if there's a deadline on this matter. I know that the NCOP will be dealing with the adjustments appropriation bill and so on early in January. And then, of course, we have the State of the Nation around about 14, 13 February, and then the budget after that. So I don't have a specific deadline for this, Honourable Chairperson. I do think that if the Western Cape Provincial Parliament would like to have deliberations and possibly public hearings, that will be in order. I'm just going to go on the top of my head here, the Chairperson. I cannot see how that how this bill, the timeline to have it passed, it can be so short that we can't allow provinces or ask provinces to shorten those periods. This bill has been coming from 2018. So, Chair, I'm relying here on my logic of this matter. And I want to say to the Western Cape Provincial Parliament, I don't think there's a deadline, but of course, the matter needs to be finalized. It has been coming a long way. So I'm not going to say end of February or anything, because there is no deadline that I'm aware of. If I become aware of one, I can always liaise with the people I've liaised with the Parliament and advise you on that. But I think you're free to decide how to deal with this in the new year, in the early new year. Thank you, Honourable Chair. I hope that helps a little bit. Thanks.
Thanks, Advocate Jenkins. Certainly it does. And I think, we would probably, in due course, maybe we would just follow that up with, with some form of written question, just to gain clarification on that process. I certainly don't think that we would want to extend the process beyond, something like a reasonable time. I'm looking at other members, whether members have any further questions and they would like clarity on any matter, because if we don't, then I think, then we can obviously release all of the other participants who I'm sure have got a fair bit of work to do for the rest of this afternoon. So let me just see if there are any hands that may be there. It doesn't look like it to me. Yes, Mr. Vermeulen.
Chairperson, thank you so much. I just want to make a comment or two before, while we have everybody online, especially Advocate Cooley as well. Just two comments, really. Firstly, yes, usually, Chairperson, we receive, once a NCOP bill is referred to us, we receive a program from that specific NCOP committee to say this is the date, obviously, that you need to submit your negotiating mandate and then your final mandate. In this case, there won't be a negotiating mandate. But the bottom line is, also just to lash on what Advocate Jenkins has said, there's no program that we have received yet from the NCOP committee. So this D version of the bill has been with us or with provinces for quite a while now. And I think the committee has made great strides, this committee, by having this comprehensive meeting today, Chairperson, even in the absence of there being a program from the NCOP committee. So we are moving forward because we have our own authority and responsibilities. But Chairperson, what I really want to say is, and I'm sure we'll get that program from the NCOP committee, if we're lucky, Chairperson, before the end of the year, which may not happen, either we're going to get it from them next year. I don't even want to say early, because, you know, after holidays and so on, we might get it in February. And I'm just thinking practically. But Chairperson, what I want to get at is it is not a very usual situation where committees deal with voting mandates. It doesn't happen very often. It happens once in a blue moon. Usually the process goes smoothly, where a committee deals with a negotiating mandate, and then the process moves forward, and then there's final mandates submitted, and things move on. Now, the point I'm getting at is, and Chairperson, this is where I also want to ask a question. Maybe it can help me and everybody. Advocate Mpo has said that, I've explained why public participation is now also important, because there's now been quite some significant changes in the D version of the bill. But Chairperson, this is my question just for clarity, maybe through you to Advocate. Does that mean that our public participation will have a different slant than usual? Because usually when we ask for public participation during the negotiating mandate stage, the public gives their input and their suggestions on what they would like to see in the bill. In this case, the voting mandate would either say, we support the bill, or we don't support. There's no longer any room for negotiation. So does that mean that the public input that the committee may solicit will then basically ask for an evidence-based approach of why we should support the bill or not support the bill, because there's no room for negotiation? And I think that it's important for us to all understand that process. Thank you, Chairperson.
Thank you very much, Mr. Vermeulen. I think that is a very valid and important question, and hopefully Advocate Jenkins can guide us there.
Yes, thank you for that question, Honourable Chair. This is why, Chairperson, I came to my opinion that the Constitution does not contemplate public hearings in the mediation process. There's two reasons. One, of course, the mediation process, and let's forget about the time frames that we're having here. Let's take a normal mediation process. Normally, a mediation process will be at the end of the legislative journey of a bill through Parliament. It would be when the bill is not 76 bill that the NCOP does not want to process or cannot process, or a bill that has gone back to the NA and the NA doesn't want to process the amendments of the NCOP, a 76 bill. So it's right at the end of the process when the houses are in a position to make a decision. So what we then have is the mediation process. It's 30 days. And as I said, I don't think the Constitution contemplates matters there, mostly because all the matters has been considered. Yes, the mediation process may, as in this case, return to the original version of the bill where we have a board and not a regulator, and basically remove that amendment that was proposed. And so, but whether, you know, in my view, the mediation process can actually have a complete new version, and the Constitution is really quiet on that matter. But my reading of it is that for Parliament, we do not have to have it during mediation. But what we then, when we send it to provinces, and this is it's an area where I'm not, I mean, I don't want to say you can't or you should not. I would say a provincial legislature, in terms of the constitution, the same with the National Assembly and the NCOP, in all its processes, not just a legislative process, also in your oversight process, must facilitate some kind of reasonable participation. So my view is that if the provincial legislature, in this case, the Western Cape Provincial Parliament, is of the view that for its own members and for discussing this matter with the public, it's necessary, then I think the power of the legislature prevails and you should do that. But as I said in the beginning, there's no scope for making amendments to the bill as it is. Now, that's an interesting point, and that's the second area where I'm saying the Constitution didn't contemplate it, because the Constitutional Court has indicated in both, I think, in Lamosa as well as in Mogale, that you have to, as a member, have an open mind, as a committee, have an open mind to the submissions from the public. It does not mean you have to accept them, but at least you must come with an open mind. You must be persuasible, if there is such an English word, to the matter. Now, in this instance, that does not feature. You can't come with an open mind unless it's for a yes or a no to approve the version that's before you, which in a way for me indicates that it's not necessary, or the Constitution didn't contemplate that type of public participation. Let me call it that. It does not mean that that there's no need for public participation. I've heard your legal advisor indicate that it's necessary. I would not argue with that, but I would say that the nature of the public participation should be very clear to those making submissions, because people spend money and time on making submissions. So out of respect of that process, one needs to say to them, this is a bill, a D version that's from a mediation committee. The question before the House is merely to accept it or not accept it. And if people want to make further submissions on that, they are welcome. So I cannot see public participation being necessary beyond that. But Chair, it is, yeah, let me leave it at that. I hope I've answered the question. Thank you.
Thank you, Advocate Jenkins. I think you've certainly given us guidance there. Okay, I'm just looking to see on what we're dealing with. I think Member Nkondlo, I think that's possibly what you've written in the chat. There's perhaps something we can then just pick up as a committee afterwards, unless there is a specific question that you may want to try again while we've got the full platform here. But otherwise, I think I want to thank all the participants today for the briefings that they've provided to us, to the DTIC, to Advocate Jenkins, to the Western Cape Gambling and Racing Board, as well as to the legal team that have been with us. And in that, I wish to thank the full teams that have been involved here and have participated and have provided very valuable insight to us by way of the presentations that have both been sent to us and been presented today. So with that, you are now free to leave us. And yeah, thank you very much. And then the committee will stay behind so that we can just deal with a number of aspects here. I see from the Gambling Board, is there something that you wish to comment on? Or Advocate Kulik, please go ahead.
Chair, I just wanted to confirm whether I'm still needed in the meeting.
I think you also then free to leave at this stage. And I noticed just the Gambling Boardroom microphone seems to have come alive.
Thank you, Chairperson. No, there's no further from the Gambling Board. we thank you once again for the invitation.
Thank you. Thanks very much to everyone for joining us today. It's much appreciated.
Thank you, Chair. I'm out of here. Thank you.
Thank you,
Thanks.
Chair.
Bye-bye.
Thanks, Chair. Thanks.
Thank you. I think we are basically down to the committee team at this stage, and we can now perhaps just have some of our own thoughts on this process. It certainly seems to be in a long and contorted process to get where we are without any specific dates as to how we need to take the process forward. Bearing in mind that the mediation committee had already sat a number of months ago, and there certainly seem to be quite a number of issues that remain contentious, certainly in terms of what we in the Western Cape have indicated being certain amendments that we were looking for, and presumably there are a number of matters then in respect of the other provinces as well. I don't know if we got comments at this stage, committee members, and then also on a way forward, how are we going to take this forward? Member Bryant.
Thanks very much, Chair. Yeah, I mean, I agree with your sentiment. It is a contorted process. I'm reminded of a similar item which we had, which was the Independent Municipal Demarcation Authority Bill, where we also had some challenges with regards to public participation and a process that had hung over from a previous term of Parliament to the current one. And, the unfortunate reality is sometimes one has to, I wouldn't say start again, but ensure that all the I's are dotted and the T's are crossed if we actually want to make a proper, valuable, considered contribution. And I think taking into consideration the mediation process, taking into consideration all of the other factors and aspects that I think we need to really apply our minds to. It's certainly not something that we could make any kind of a decision on right now. I do think that there will be some form of a requirement for public participation, depending on what shape that takes. But perhaps, as suggested by the legal advisors, we reconvene on this item next year to discuss it further. But I'm also interested to hear the thoughts of the other committee members and you as to how we should take this forward. Thanks.
Yes, thanks. Thanks very much, Member Bryant. Yes, I think, to me, I'm almost wondering whether there is not some form of written request that we put through to the NCEOP to ask them in terms of what the timing process is on this matter, for them to give us that form of guideline, and while also mentioning that if we were to provide some form of a mandate, we would need the necessary time to deal with the matter, as well as take into consideration whether we would need to have further public participation. So I suppose that, to me, would be like point one. I suppose the second issue that we need to do is to consolidate the briefings that we have been provided with at this stage, along with the detailed views that Provincial Treasury may well have, or that the Premier's office might well have in relation to this matter. That they could possibly give us some form of further briefing take the matter forward. And then, thirdly, it does, to me, it would appear that we would need to strongly consider the need for further public participation, which to me, if we were to do that, it's probably something that we could feasibly, at the earliest, only hold during February. And, the question then is whether we then, try and tackle and review the situation come possibly late January. I suppose those are the type of thoughts that I have at this stage. I think, what's also very clear is that that the representations that have been made, there are a number of those that have not been taken into consideration, and certainly a number of areas that then clash, it would appear, with our own Western Cape laws, and this whole issue of the quorum issue of that NSEMS and the National Inspectorate, and therefore the duplication that is taking place, and the impact that then has on the provincial ability to raise revenue from the gambling source in terms of the Constitution. I don't know if there are any thoughts on that. Okay, any comments from yourselves?
Chair, I think it's just you and I at the moment, but I'm more than happy with that.
Sorry, Chair?
Yes, go ahead. Yeah.
Sorry, I've been struggling to unmute myself. At last, I managed. Apologies. Chair, I think the safest bet for me in this regard is always get the parliamentary legal advice in writing in terms of the process going forward. I think that's the safest bet instead of going to NCOP. But rather, I will say that this committee put it formally in writing through you, Chair, to our parliamentary legal services. They need to give us a opinion or a legal advice in terms of what you have just indicated regarding the way forward.
Yes, look, I certainly omitted to just include that the word legal advice there, because I think that goes without saying. Member Constable.
Yeah, thank you, Chair. I totally agree with what Member Masipa is saying. Let's get legal advice and see what they are saying, and then move from there. Thank you.
Okay. Member Nkondlo, I'm not sure if you are in a position to use your mic at this stage, or whether you go along with the idea. I mean, if you are happy with that, you can perhaps just indicate for us. Otherwise, I think if that is what the general view is of the committee, then hopefully that is how we can take it forward. I'm just looking at procedural officer as well, whether we've captured that aspect of it. I see Member Van Winden's also on board, has given a thumbs up. I see Mr. Vermeulen.
Chairperson, thank you. I just want to make sure that Zahida and I am clear, because I'm slightly not clear at this stage. I'm not sure what legal advice the committee wants to ask for. Is it now in terms of the process going forward? unless I don't understand completely, because the legal advisors won't really give advice in terms of the process or procedure, because the process is now it's determined by the way I understand it, Chairperson. We know that there's no NCOP program provided yet at this stage, but our committee, we can continue with our processes. So I just want to be clear. What are we going to ask in terms of the legal advice? I think if that's clarified, then I'll be satisfied, Chairperson.
Yes, okay. I think
thank you.
The colleagues can perhaps also just do that. But to me, it was that for the legal team then basically to try and phrase or capsulate what the request that we put to NCOP and say, look, we've now received briefings on it. We believe that the mediation committee has now met. What is the process going forward? But maybe Member Bryant and Member Masipa could assist us there. And then I see Ms. Adams as well.
Yeah, Chair, I mean, I think that's my understanding of it as well. But maybe a little bit more specifically, just in terms of what Ms. Kula has already touched on when it comes to the need for public participation, because as Mr. Vermeulen said, there's nothing preventing this committee from starting public participation processes next year if need be. So perhaps if we can just get some clarity on that in anticipation of the meeting for next year, we can decide on the public participation processes, because I don't think that's going to be taking place today in terms of those decisions. That's my understanding, but I also take Mr. Vermeulen's point that it's our decision as a committee as to take this forward. I think there's only so much advice we can get from the legal advisors.
Yeah, look, to me, I think Advocate Jenkins has in effect conceded that the province needs to do what it needs to do in terms of public participation. And there, I think we would probably agree with Advocate Kule. But the difficulty that I think we have at this stage is we're not quite sure on what the next move is going to be by the mediation committee. It does seem that at this stage that we can't take any more comments. It's almost a yes/no at this stage. I see Mr. Vermeulen. I see Member Masipa's hand is down, and Ms. Adams's hand is down as well. Mr. Vermeulen.
Chairperson, thank you. Just on this point of the mediation committee, the mediation committee, Chairperson, is out of the picture now, because they have provided this D version of the bill. And this D version of the bill have now been referred to all the provinces for input, or for the next step to provide the voting mandate, of which we have not received the time frame by when the NCOP wants this. But this bill is now with the provinces, and it's with I'm not sure which select committee is. Aida, you can help me. Sorry, Chairperson, through you. I know Ms. Adams' hand is up as well. Maybe she wants to make a comment. But in terms of the process, Chairperson, the mediation committee is no longer in the picture. They've done their work. We sit now with the D version of the bill. I think the committee has sort of agreed now that some form of public participation is needed, but we just don't know what the program is. And I don't expect, Chairperson, that it's going to be that soon, because so many things will happen. I think we've already discussed it. The NCOP will have to give a program, and that may be for the first quarter of next year, or later. I don't know. But yeah, thank you, Chair.
Okay, look, I think, I suppose what we're trying to do is just to get to what that next step is, Ms. Adams.
Thank you, Chair. I wanted to agree with my senior, Mr. Vermeulen, to a point. I think the process now lies with us in determining, firstly, whether there's a public participation process that we want to do.
and how the public participation process looks. We've already received a full formal legal opinion from Advocate Kwile, which members have, which can guide us on the way forward. And then also just to note that that letter that we want to write is going to go through the Speaker's office. So it won't be from the Standing Committee. It will be from Speaker to the NCLP Chair. That's where the ball now lies. That's who we liaise with. And who we also liaise with in terms of whether there would be a program. And my understanding is that since the bill, in their opinion, is at the tail end, I don't think that there will be a program like we would ordinarily receive, where they would give you a deadline for negotiating mandates and the deadline for the final mandate, etc. So we are basically just waiting on the deadline for when the voting mandate must be submitted. And as far as I know, the last time we asked, they didn't have one yet. So then we can follow up in that letter, like you said, we can get guidance on when the deadline for the voting mandate would be. And then in that same letter, let them know that we might be engaging in a public participation process, and that needs to be taken into account when they decide what the deadline will be. I think it's important that we just keep them informed that that might be a process of ours and that we might require more time for that process. So that's how we can move forward with our communication to the NCLP via the Speaker.
Okay, thank you, Ms. Adams, because that sounds like an elegant way to approach the matter then, and because I think what I'm just thinking in terms, we need to get some form of understanding as to when this we need to undertake, for instance, the public participation process, if that is what we are going to do, because we don't want to, commence with a public participation process and a week later something else has happened in this whole process that then, causes further confusion. So I think, to me, that is what you've now indicated, Zaida, is what the resolution then in effect is, that we follow the route that you've indicated, and once we've got clarification for that, it will come back to us at the committee, and then we will set in motion the further set of decisions that we need to make, if that helps to clarify. I don't remember, Masipa, were you going to say something? Or I think Ms. Adams is giving us a thumbs up over there.
I'm covered, Chair. I think the way it is, I think committee, we must just make a call forward. If the legal opinion that we've been provided, the spare, just move the way forward in terms of preparing ourselves for public hearing or not. But I would assume that we will have to really take a public hearing, because I mean, technically the bill is lapsed, so we need to now in terms of our next going forward. Thanks.
Yeah, no, thanks. I think that deals with it. I think we've got that element of clarity. So it does mean that we can probably sort of keep our swimsuits going a little bit longer in January, and not have to change into more formal wear a lot earlier because of this bill. Hopefully that is so. So I think with that, I would like to thank everybody for being with us this afternoon. Enjoy the rest of the afternoon. Ms. Adams.
Apologies, Chair, we have documents to consider and adopt, unless you want to carry it over to our next meeting.
Oh, yes. I did a few minutes ago. I still remembered that, but I was so enticed by the idea that we could complete the meeting now that I forgot about it. Okay, let us deal with those items. Can you flight them for us, please? Okay, so this is our draft report on the annual report that for Provincial Treasury and for the Western Cape Gambling and Racing Board. Hopefully everybody has had a chance to have a look through that. Okay, so we got resolutions down there at the bottom. Maybe if we just look at if we just stop there for a moment. I think it's item 3. So that deals with the whole aspect of the PES, the financial recoverability, and then we were asking a few questions of the gambling board on the relocation of the casino, and then yeah, and then I think that is basically in short what we've dealt with there. Do we have the yays and the nays and the proposals for this? Any hands wishing to propose? I see Member Constable. And I see, I think, is it Member Mbombo? Yes.
Yes.
Proposing and seconding, I hope.
Yes.
Okay, good. Thank you. Thank you for that. Okay, and then do we have another one, Ms. Adams? We have, this was on the 31st of October, in which we dealt with, that was in fact the minutes from the annual report from that meeting as such. So, and if everybody is happy, then proposer and seconder for that. Okay, thank you, Member Constable. I think we will give you the lollipop as being first up, and then Member Mbombo will get the second lollipop for the day. Thank you very much. Right, Ms. Adams, you got more tricks for us?
Well, good, Chair. Good to adjourn.
Okay. Right, okay, thanks very much. I think that then brings our meeting to a conclusion. The meeting is adjourned. Enjoy the afternoon further.